Hello everyone, thank you for joining today's webinar. First, let me introduce myself. I'm Junfei Wang, a senior patent attorney from Shanghai Patent and Trademark Law Office. Over the past years, I've focused on handling patent applications, re-examinations, and invalidations in the field of photoelectronics. This hands-on experience has let me tackle many tricky issues, including the one we will dive into today: how to respond when a patent application is rejected under Article 5 of China's patent law. At the beginning, let's take a look at an overview of Article 5. In the later parts, I will use a real case study involving a crypto integration platform to explore in detail how to address the rejection under Article 5. First, let's make sure we are on the same page about why Article 5 matters. It's a fundamental gatekeeper for patent eligibility, with two key parts. Paragraph 1. No patent right shall be granted for any invention creation that violates laws or social morality, or that is detrimental to the public interest. This is the focus of our case today. Paragraph 2. No patent right shall be granted for any invention creation where the acquisition or utilization of the genetic resources. So why this article so important? Because it relates directly to the social impact and compliance of an invention. An application deemed detrimental to public interest can be directly rejected during substantive examination without the consideration of its novelty or inventiveness. Rejections under detrimental to the public interest can feel vague at first, and this is especially challenging for patent applications in emerging or sensitive fields, such as blockchain, digital assets, e-cigarettes, or certain biotechnologies, where the examiners are likely to invoke this article. But as we will see, with the right approach, they are addressable. Let's start with the case that inspired this talk. Now, let's dive into our case study. The invention in question is a crypto integration platform, a technical system designed to make digital transactions more secure. Here's the quick backstory of the case. Initially, the application was rejected by the examination division as being detrimental to the public interest under Article 5.1. Our examination request was filed with our argument and revisions, and the examination division revoked the rejection. In the follow-up of its action, only formality issues are indicated to be overcome to allow this case. The Article 5 issue was completely resolved. So why was it rejected in the first place? And how did we turn it around? To answer that, we need to work through how the examiner's rejections evolved, because understanding their logic is the first step to responding effectively. The examiner's concerns grew more specific over 3 rounds of office action. Let's break each down step by step. In the first round, the examiner pointed to a detail in the specification which mentioned examples of digital transactional items the platform could handle: currency, tokens, and cryptocurrency, including Bitcoin. The examiner's argument was straightforward. According to the relevant Chinese policies, trading of Bitcoin and other virtual currencies is prohibited, as it may disrupt financial order. Since the application mentioned Bitcoin, the examiner asserted the invention detrimental to the public interest. At this point, we noticed a key loophole. The Bitcoin reference was just an example. It wasn't part of the core technical solution. But we knew we could not stop at that observation alone. In the second round, the examiners stopped focusing only on the Bitcoin and argued that the platform's implementation would inevitably involve virtual currency transactions, no matter what examples we used. In his view, any digital transaction facilitated by the platform was equivalent to virtual currency trading. This was a big challenge. The examiner was no longer just criticizing our wording. It was clear the examiner was determined to tightly associate our application with the sensitive term virtual currency. In the third round, the examiner issued a final rejection. The examiner cited a critical document, an announcement from the People's Bank of China that bans token-based financing. They argued that the token mentioned in the specification was a type of virtual currency, and thus the entire invention violated Article 5. By this point, the examiner's logic was clear. This platform involves virtual currency transactions, which is detrimental to the public interest. Before we dive into our response, let's ground this in official rules, because every argument needs to tie back to the law. The guideline for patent examination defines detrimental to public interest clearly, and it includes an exception. First, the expression detrimental to public interest means that the exploitation or use of invention creation may cause detriment to the public or the society, or may disrupt the normal order of the state and the society. Examples include devices that intentionally injure people, inventions which causes severe pollution, disrupt ecological balance. Now, the exception. This is what became the breakthrough point of our case. If an invention creation is possibly detrimental to public interest in its abuse, it shall not be refused to grant a patent right. In simple terms, the invention itself must be inherently harmful, not just something that could be misused. That's the line we needed to draw for our crypto platform. We use 3 interrelated strategies to address the rejection. Let's go through each one. The first strategy is to delete non-core sensitive terms. First, we clean up the specification. The terms Bitcoin, virtual currency, and token were never part of the core technical solution. They were just examples of what the platform could handle. So we deleted every mention of these terms. Why did this matter? It removed the examiner's easy target, the specific words that were linking the invention to illegal activity. And since these terms were not in the claims, Deleting them did not weaken the application or make the claims unsupported. This was a quick, practical first step, but it was not enough on its own. We needed to address the examiner's bigger concern that the technology itself was tied to virtual currency. The second strategy is to argue the invention's core is neutral, which means not inherently harmful. To help the examiner understand, we spent a lot of time in our response clarifying the platform's actual purpose. Our system does not care whether the item being traded is Bitcoin, a digital ticket, or a software license key. Its core workflow is using the same key to bind and authorize both the asset transfer and the payment actions. Only when both are properly authorized is the transaction completed. It's like putting a linked security lock on a digital transaction. This lock itself is neutral and beneficial. Its purpose is to prevent fraud and ensure transaction security. This invention can be realized without any virtual currency at all, so it will not be detrimental to public interest. The third strategy is to use policy and real-life examples to build credibility. To strengthen our argument, we added 2 layers of context that showed the invention was not just legal but valuable. Policy alignment. We noted that the platform relies on blockchain technology, and blockchain is a priority for China's digital economic development. We even cited other blockchain-related patents that the Patent Office had already allowed, to prove that this field is patent eligible when the technology serves legal goals. Everyday analogy. We held several telephone discussions with the examiner. In these calls and in our written response, we compared the platform to common online payments. Thinking about buying a movie on a streaming app, you pay with WeChat Pay or Alipay using fiat currency. The platform verifies the payment, and you get access to the movie. That's a legal digital transaction, and it works exactly like the invention's platform. We asked the examiner, if buying a movie online is illegal, why would a platform that secures such transaction be illegal? Our technical solution could be perfectly applied in such legal scenarios. We use this vivid example to demonstrate to the examiner that there was no necessary connection between our technology and illegal virtual currency trading. Our efforts succeeded. After examination, the China National Intellectual Property Administration overturned the decision on rejection. The case was sent back to the original examiner for continued prosecution. In the subsequent office action, the examiner only raised formality issues. This means the Article 5 rejection was completely addressed. This case taught us a valuable lesson. The best part about this case is that its lessons are not one time. Here are 2 actionable takeaways we can use if we ever face an Article 5 rejection. If the office action targets specific sensitive terms used as examples in the specification. For example, cannabis, stimulants, names of specific virtual currencies. And these terms are not essential to the claims or the core of the invention. The most direct and effective method is to delete them from the specification. This usually does not affect the scope of patent protection. Then prove your invention is neutral, not inherently harmful. If the invention has potential illegal uses, implicitly exclude them in the response or amendment. For example, our platform can function without virtual currency transaction. If the technical solution itself is neutral and lawful, as in this case, the focus of the argument could be clarify boundaries, explain what the invention is, and more importantly, what it is not. Then focus on the core, emphasize the technical problem solved and the neutral nature of the solution. Then provide legal examples. Give a concrete, entirely legal application scenario to help the examiner visualize it. And if possible, cite policy. Connect the invention to industries encouraged by the national policy. For example, the digital economy, blockchain technology applications. To wrap up, rejections under Article 5 can feel overwhelming at first, but they are not unbeatable. The key is to focus on the invention's core. Is it inherently harmful or just potentially misused? By learning on the guideline, aligning with policy, and using clear examples, you can turn a rejection into an approval, just like we did with the crypto platform. I hope this case study and these strategies provide you with some useful insights. That concludes my sharing. Here's my contact information. Please feel free to reach out after the webinar for further discussion on related topics. Thank you all for your attention.